I had a very interesting question raised in a live stream about enforcing a foreign judgment in the United Kingdom. Now, whilst this subject is far too vast to go into in any great detail, I did think it was worth providing something of an overview for those that are interested. But first of all, if you're new to me, I'm a barrister who helps you understand law, so make sure you hit that subscribe button and perhaps one of your questions will find its way into a video very soon. So of course the aim and the objective of any civil litigation is to enforce a judgment if you are successful. Whether that's a money judgment or whether it is an order of the court prohibiting someone else or another company from doing something, or ordering that they do so. But the question raised is, what do you do with a judgment that you've obtained in a foreign jurisdiction? Now, for the purposes of this video, I'm going to talk about money judgments predominantly because there are several different types of judgments, such as divorce settlements, which I can cover in another video. As a starting point, there is a difference between getting a judgment recognised and then getting a judgment enforced, but getting it recognised is usually the first step in this process. Once a judgment is recognised, it really ought to prevent a party from relitigating it in the hopes of a better decision, or re-defending it in the hopes of a better decision. Whereas enforcement of a judgment, quite apart, is taking some actual step in order to enforce that judgment. If you hold a judgment in your favour, you become a judgment creditor until that judgment has been fulfilled and you have been paid. If you've had a judgment against you, you become a judgment debtor. In other words, you owe the judgment creditor a debt under the judgment. As a judgment creditor, you can take these positive steps against the judgment debtor in order to settle your judgment debt. This may very well be by seizing the judgment debtor's assets, such as property, or even freezing money in a bank account, or obtaining an attachment to earnings, which is a deduction from money earned in a salary paid by the employer. An attachment to earnings, for example, would be deducted before the salary is paid to the judgment debtor. However, before that happens, as I said, you need to get the judgment recognised. No judgment can be enforced unless, of course, it has been recognised first. And whilst there are certain principles apply in recognising a judgment, wherever it's come from, there aren't any special procedures for this like there are, most certainly, with enforcing a judgment. So with so many different places and so many different systems, let's talk about how we begin to think about getting a judgment recognised and then moving on to enforcement steps. And this is broken down in what we call a regime. So there are broadly 4 different regimes under which we can seek to enforce a foreign judgment in England and Wales. This will depend on from where the judgment originates and the date the proceedings commenced. So firstly, we have the UK regime. It should go without saying that judgments from England and Wales can be enforced in England and Wales with no particular recognition. It is a recognised judgment because that is where it has been issued. So outside of England and Wales, we have the rest of the UK regime, which is of course Scotland and Northern Ireland. Next, and very slightly tricky, we have the European regime. This will apply to proceedings that were issued before the 31st of December 2020. And just to note that this regime will not apply to cases issued later. Those judgments that originate from proceedings that were issued after that date will come under the common law regime, which encompasses the United States. Then, of course, we have judgments from most of the other Commonwealth states, which is the statutory regime. And aside from these 4 principal regimes, we also have the Hague Convention on the Choice of Court Agreements. And again, until the 31st of December 2020, there was a short list of countries to which this would ordinarily apply to. So a very broad outline of how you would set about enforcing a judgment from one of those regimes would be as follows. As you'll remember from the outset of the video, the typical starting point would be to get a judgment recognised. And that's the case for Scotland and Northern Ireland. You would go back to the original court issuing the judgment and get a certificate. And with a few twists and caveats, you can then apply to the High Court to register the judgment. Looking at EU cases that were instigated before the 31st of December 2020, you are entitled to enforce the judgment as though it were an English judgment in the English courts. The judgment creditor can use all of the normal procedures and methods of enforcement, which I'm going to come back to after talking about the regimes. As for cases that fall under the common law regime, which includes cases instigated after the 31st of December 2020 in the EU and United States, for example, this is a little bit more complicated. For example, to be enforceable at common law, a judgment must be for a definitive sum of money. So for example, an injunction ordered by a court in an EU state after this date would no longer be enforceable in England. There are also some complex rules about jurisdiction and consent between territories. So typically, enforcement of a foreign judgment under common law will require fresh proceedings. although the judgment creditor may be able to obtain summary judgment on the basis that there has already been a judgment in his or her favour, although this is going to require further steps before the usual steps will be open for enforcement. As to enforcement of judgments from Commonwealth and some other countries under the statutory regime, there are several acts and statutory instruments that cover different countries, and again, broadly speaking, it needs to be for a money judgment for a definitive sum, and it needs broadly to start with a recognition or certification of the judgment and then following various steps. So again, this is a very complex area, so that would be your starting point, but I would urge you to seek formal legal advice depending on your specific circumstances. As to the types of enforcement, once you've passed these hurdles of getting a judgment recognised and or certified and following those procedures depending on where your judgment is from, typically you will have similar types of enforcement available to you, which would be third-party debt orders, which is, for example, when your judgment debtor has a bank account and you have the details. You can apply to have those funds frozen and paid over to you, although before that happens, the judgment debtor will have an opportunity to argue at court as to why that shouldn't happen. Again, that's a subject for another video on each of these enforcement areas. There are also writs and warrants of control, and there are charging orders which can apply to properties. So as I said, each of these areas can warrant an in-depth video, but I just wanted to give a very broad overview as to how we would go about looking at enforcing a foreign judgment, because it is extremely complicated. So with that said, I hope you found this video useful. Make sure you drop your questions and comments in the box below. Make sure you check out Black Belt Secrets if you want to hear my stories, how I became a barrister, why I do what I do, and hit that subscribe button here so you don't miss out on new videos. In the meantime, thanks for watching. I'll see you next time.